Hello everyone, this is Tom Fox and I'd like to welcome you to episode 8 of Compliance Into the Weeds, a podcast with Tom Fox and Matt Kelly. Matt and I go into the weeds today about two subjects. The first one is risk assessments, big data, and the compliance function going forward. Matt has some really interesting insights and thoughts about what the prevalence of big data might mean for the compliance profession, internal audit, and the compliance function. We then take a look at the Yates Memo, and much to my surprise, Matt has agreed with many of the critiques by the Chamber of Commerce, so we explore this at some length, what the new focus on individual prosecutions might mean for corporations, senior executives, and boards of directors. The episode comes in at just over 22 minutes. Thank you very much for listening, and I look forward to visiting with you in the next episode. Hello everyone, this is Tom Fox, and I'd like to welcome you to another episode of Compliance Into the Weeds with my good friend Matt Kelly. Matt, hello.
Hi Tom, it's always a pleasure to talk with you.
Well, Matt, you've had a couple of interesting blog posts that I thought really lended themselves to maybe going into the weeds and really geeking out here, because you have a blog post entitled Conducting Risk Assessments in a Big Data Future. And they're just, I counted 8 different things, I think, going on here. You really packed a lot into this post, but I guess maybe and even to start with, how your opening paragraph talked about a article you saw on the ACL in-house blog about the future of internal audit. So maybe that's just the place to start, because I rarely see you start with an opening line like that.
Yeah, sure. So for any compliance people who are unfamiliar with ACL, they're a software firm that is generally tilted towards the internal audit crowd. So they're fairly well known, and I bet your internal auditors would probably know who this vendor is. But I was looking at their in-house blog, which is very good and worth reading if you care about audit issues too. They were talking about internal audit in the future of big data. And specifically, the writer was saying that those internal auditors who are highly skilled at data analytics are now in much more demand and are getting more money. I don't think that's news to anybody. The author said that really he foresees a world where traditional auditors really won't even have much demand for them anymore. This is all going to be data analytics now. I'm not going to go down that road about if traditional auditors are going to go away, but I think even compliance people would agree that if you are better at data analytics, you are going to be more in demand. I think that's true of compliance. I think it's true of internal audit. But that got me really to thinking about how the nature of a risk assessment is probably going to change or maybe converge between the compliance risk assessments that compliance officers do and the big enterprise risk assessments that internal auditors do.
Well, Matt, before we even get to that point, I
Sure.
really want to focus on the first couple of paragraphs, because although you say it's not that surprising that auditors are going to need to have better skills of working around big data, I really took that point for more than just auditors, the compliance professionals, compliance practitioners, chief compliance officers, the legal department, a wide variety of corporate functions. So when I read those opening 2 paragraphs, it wasn't that it was not surprising. It's just that I saw an application much broader than simply internal audit. And since I'm a compliance kind of guy, I think that your point resonated with me, that anyone who wants to be a chief compliance officer is going to have to learn how to at least help to set up a measurement program around big data, but certainly around analyzing it.
I agree. I think it's going to be true no matter what job you're going to have in large organizations in the future. We could talk about marketing. Marketing people would agree with all this too, that it's going to be about looking at collections of data that may not even be in the same format or talking about the same thing, but collections of data and how you can sift out patterns that you want to know about. That's really what we're getting at, whether it's compliance and talking about workforce conduct issues or audit for financial reporting or anything else. But I could not agree more with what you just said.
So I did interrupt you because you were on to really the next point about how this would all work into a risk assessment, an enterprise risk assessment, a compliance-based risk assessment. You really have a lot going on here, so why don't you unpack it for us?
So what I'm thinking about is that I believe eventually we're going to have so many exacting compliance regulations that the compliance risk is going to sort of evolve into being just another enterprise risk. And to the point we were just talking about, if you're going to be using data analytics to study these risks at all, I think we're going to see the enterprise risk assessment and the compliance risk assessment. I don't know that they're going to converge, but they might. But I think that they will look and feel very similar. And I just wonder how this is going to play out if, let's take third-party risks, for example, third-party oversight for anti-bribery or human trafficking or anything like that. Those are compliance risks, I would say. But eventually, if there's going to be so much pressure on them, they become so important, that's going to kind of evolve into better supply chain management is an enterprise risk. Well, then who oversees that? Who does that risk assessment? Is it audit? Is it compliance? Do they do it together? If they do it together, who brings what sort of expertise to the table? I don't know if we're going to get there in 5 years or 10 years. I suspect some companies are probably close to that today. But that's the sort of convergence I suspect we're going to start to see, especially if all that these senior executives are doing, whether they're in the third line of defense like audit or the second line of defense like compliance, if we're doing data analysis exercises. Tell me how that really, how one is going to be different from the other. I'm not really sure that it will be. So that's where I was going with that. One other point that I was thinking of then is so I started looking at some charters of audit committees because, of course, audit committees are the ultimate party responsible for everything in the universe these days. We all throw everything at the audit committee. How many charters are defining risk management and risk assessment in these ways? Do they see them as separate, the enterprise risk assessment and compliance risk? Do they see them as interrelated? Do they see them as combined? It looks to me still that most large companies still identify the enterprise risk assessment as what internal audit does, and the compliance burden falls to the compliance officer. And they see them as very separate things that I don't know what the metaphor is. I wouldn't say they're on parallel tracks, but, they're on tracks that intersect only from time to time. I think in the future we're going to see these two things almost converge into one track. How are we going to get there? I don't know, but that's where this whole analysis was going with that ACL blog originally and just kind of shoved me thinking down that path.
When I read through this part of your blog, Matt, it really struck me about the business process nature of compliance. Mm-hmm. And that's one of the things you and I have visited about a few times over the past couple of years, and how can you move compliance into the business process? Well, here it seemed to me you were saying that, but you were coming at it in a different direction because you picked up on the internal audit function and how their use of big data really would mirror, if I can pronounce that word correctly, what compliance needs to do so that there may be a true convergence there.
I think that might happen. And people should remember that just earlier this year, the Institute for Internal Auditors, they put out some guidance about how internal audit can do some second line of defense functions. Now, there's no conspiracy. The IIA is not looking to hijack the compliance profession and take it over. There's nothing like that that's going on. But I do think that maybe the nature of what we're looking at here and how business processes work, it's going to be easier to sort of blend a lot of audit and compliance functions into one sort of operational risk management sort of a thing. And, really what you're going to be looking at is data to keep an eye on all of that. Maybe that's the direction we're going to go in. I'm not sure. But you can't get away from thinking about those ideas. If you start looking at where these trends are going, I'm hard-pressed to see how you would not go down this path of thinking these ideas.
And one other thing, or the next thing that really struck me was when you were listing the different challenges that a corporation would have, and you specifically mentioned pressure on third-party oversight, supply chain efficiencies, increased government regulation. The thing that really struck me there was that typically a compliance officer would not identify supply chain efficiencies as a risk of the compliance function. And so the compliance function probably wouldn't analyze that in any way. But because this information in the form of big data is driven into the business process, it can be, if a company can extract it through this collection that you've talked about, it's really more than simply risk. It's showing how, I would say, compliance drives greater business efficiency, but you made me look at it in another way that internal audit can also bring that greater business efficiency.
I think so, and I think auditors would say that that's what they do, is they look for ways to improve operations. Certainly efficiency is part of that. Certainly, if they came across a third-party oversight function that was rife with corruption, they would absolutely say that this is terrible, we need to clean this up, but that's not efficiency, that's about good business. But they wouldn't make a distinction there. Auditors would say, this is just not working properly, we have to make it work properly. I think that they will be able to do that to a more advanced degree the more big data comes into play, and then you wonder, how does compliance and other groups, how do they sort of interact with that trend? Like I said, I don't know, but I think it's going to be a very interesting conversation to have 10 years from now and look back on what's happened between now and then.
So, like I said, I really, if you're looking for a book topic, this seems to me you packed in, I counted 6 to 8 different topics in your blog post. You really packed a lot in there, and a lot to think about. And you made me think about it in a way that I hadn't really focused on before. So kudos for putting that out there for us to consider.
Well, thank you.
So the second thing you wrote about is something that our good friends from the U.S. Chamber of Commerce released, a white paper critique of the Yates Memo.
Yes.
And as you might expect, you can probably name what the Chamber of Commerce is going to talk about. Over-criminalization of business processes, too much aggressiveness by U.S. prosecutors, unclear laws where they don't know what to follow, those types of things. But they had some specific, if not criticisms, critiques of the Yates Memo. So you wrote about this, and what did you get out of the Chamber of Commerce paper?
I got to the dark day where I had to admit I agree with the Chamber of Commerce. And people who have read my writings in the past know I generally am not a big fan of them. I think that they overreact to any reasonable regulation that comes out. But people who've read my work also know I'm not necessarily a big fan of the Yates Memo. And in this case, I don't think they're overreacting to a good regulation. I think they are properly reacting to a ill-conceived idea that is gussied up to be the Yates Memo. It's well worth reading. To be honest, the most surprising thing really is that it took the U.S. Chamber, a good 6 or 8 months to publish this. It's not like they didn't despise the Yates Memo the day it came out. I'm sure they did. But it really focuses in on a few main points that I think a lot of compliance officers would agree with, that it overcomplicates your decision about whether you should disclose, because if you are going to give all facts that you can find to get any cooperation credit at all, including those facts you could not find and why you couldn't find them, the U.S. Chamber paper says that that's going to lead to a whole lot of second guessing about your investigation methodology, and that's not a good place to be in. They also say that this really does make corporations an instrumentality of the Justice Department doing investigations, because corporate internal investigations have a whole lot more power than the feds. You can subvert people's Fifth Amendment and Sixth Amendment rights to counsel and to decline to participate. You know what? The Chamber of Commerce is right that this could happen, I think. I know some other lawyers have kind of poo-pooed it, but it weighs on my mind. I know one corporate controller, a personal acquaintance of mine, who has told me that this is happening at his company today, a mid-sized technology firm that is trying to do some investigation work for the government because they are under a regulatory probe, and the employee who's the target has declined to participate, and then he went and claimed whistleblower protection status, and they don't know what they're supposed to do here. I don't think the Yates Memo really helps any of those sort of duties. I don't know if your thoughts are different than mine, but it just seemed to be a messy situation from the start, and the Chamber has really sort of put a whole lot of words and thought around it, and it's worth reading.
So I certainly agree, and I've been concerned for some time about this deputization of corporate internal investigations. Because if you are doing an investigation, you know you're going to turn it over to the government. As a lawyer, what is your responsibility to communicate to the person you're interviewing? Do you have to advise them that anything they can and say will be used against them? Do they have the right to counsel? Do they have the right to decline to answer your questions? What about if they destroy evidence? Is that a federal crime? Or is it just some sort of civil violation or violation of corporate rules and regulations? But the confusion beyond that, I have to say I don't find that as great, because specifically to the example you cited in your blog post that you just articulated about the mid-sized company, whistleblower status has nothing to do with the Yates Memo. That's either if it's a public company, Dodd-Frank, but if it's a private company, that's some other whistleblower law. And that stands separate and apart, completely distinct from whatever incentives a corporation has under the Yates Memo. The second thing is that you always have the right to decline to talk to your internal investigation. The consequences can be a sanction in the form of job termination, but if you have a robust investigation protocol and you present that investigation protocol along with all of the information you can obtain to the Justice Department, I think if you wed the Yates Memo with the pilot program, it should give corporations and our friends at the Chamber of Commerce some comfort that the Department of Justice will take that into account. And simply because someone exercises a right to have counsel or a right to decline to visit with someone, I don't think a corporation should be sanctioned or will be sanctioned for individuals engaging in those rights. I certainly agree it will make it more difficult to do a more robust internal investigation. It may even hurt you in trying to do it sort of a root cause analysis. But I guess I don't think corporations will be punished by that under the pilot program.
That's a fair point to bring up the pilot program, and I'll be curious to see how that does try to ameliorate the very messy situation. But another thing that keeps on coming up to my mind is, I'm certain sooner or later some executive interviewing for a job at a high level is going to say, I'm happy to take it, but I want some sort of indemnification clause in my contract, or I want to guarantee that you will pay for my private counsel should I ever wind up on the wrong side of an internal investigation. And if you're a whiz-bang executive and the company really wants you, you're going to get it. However, if we mere mortals go and start demanding those sort of things, we are not going to get it. And most employees will understand that they're not going to be able to demand that on a practical level. And again, that sets in motion what everybody who talks about corporate culture says is a terrible thing to do. You're going to wind up with two classes of employees, those with the weight to cover their own rear end and those without the weight who will feel exposed. And if you feel exposed, you're just always going to get your hackles up and be uncertain about what to do. You're going to think, let me clam up, let me keep a low profile. I think it just sets a precedent of not being conducive to a healthy corporate culture where everybody feels like they're treated fairly and they are all in it together. And, as to various ideas about, could this wind up being somebody claiming a Fifth Amendment or a Sixth Amendment violation? We've all read these tort books in law school that, there are all sorts of cockamamie, bizarre fact patterns that get you to such strange decisions that wind up in court. As I've said before, I look forward to the fact pattern that is going to wind up with us saying, how did we get here? Sooner or later, this is going to wind up being in front of a judge who's just going to say, how on earth did this come up as a thing? It's going to be a thing. I don't know when. And as a third side note on the Yates Memo, and then I'll get off my soapbox, we all have to remember that in all likelihood, Sally Yates will not be Assistant Attorney General beyond, or Deputy Attorney General beyond January 20th or 21st or so. Somebody else is going to be taking her job. Does that mean we're going to have a new policy? I don't know. I look forward to it, but it's zigzagging back and forth. It does no good for companies that are just looking for a good, solid, reliable framework of how do we interact with the government. I don't know.
You raised some really interesting points.
Well, we're always up for a good Yates Memo discussion, Tom. You and I can do this every week for months on end, I think.
Well, Matt, unfortunately, we're at the end of our time. Matt blogs and at Radical Compliance, which is his website as well. He's got some great posts up. A very, very provocative thought leader in our space. So, Matt, as always, thanks very much.
Thank you, Tom. It's always a pleasure to be talking with you.
All right.